Hey everyone. Just to give you a bit of clarity here, this is the motion from Judge Lyman on the request for sanctions against Jamie Heath, the whole birth video thing. I've already done that video earlier. But no, there's no deja vu. I put this back up here just to quickly start this video. This video is going to be on Wayfarer's opposition for Stephanie Jones's motion to compel Katie Cates, the documents about who is behind the Stephanie Jones Leaks website, which I think is totally irrelevant to this, unless it has something to do with Jen Abel. I just don't see the relevance of it in this lawsuit. But that's me going off on a tangent already before we even started. But someone did ask in the comments, and I wanted to clarify my opinion of this. It's not clear whether Judge Lyman has awarded attorney's fees as a sanction against Jamie Heath as part of this court order. I think he has. So I'm going to just blow this up and just obviously I'm not a US attorney, and not actually Golden or Little Girl Attorney or Brett or any of them have a different viewpoint. I always defer to them. But Judge Lyman here is saying, she's asking for very severe sanctions. Lesser sanctions are warranted, namely production of the footage and payment of Lively's attorney's fees incurred in making this motion are sufficient. So from that wording, it reads to me like, yes, that the attorney's fees are actually part of, what he's given Lively here. However, this bit at the bottom where, it says the motion is granted in part, denied in part. This is the summary sort of paragraph, and it is kind of the order. It in itself, this is the order, and this is where the expectation on the parties, what he's ordering, what they have to do. This is where it states that, and it says he shall produce footage within 3 days of this order. It doesn't say and pay Lively her reasonable attorney's fees in making, having to make this order. And I think that's where there is confusion. And I'm not 100% sure, but, the argument that an order was, is not overtly clear has just backfired quite literally on Jamie Heath, because that was part of his kind of opposition to Lively's motion in the first place, was as, hey, the court ordered me to do this, and I did literally this. And Lyman was like, no. Lively's original motion has this and this, and you did not oppose any, so I ordered it. I would err on, if I was to err on the side of caution, then I would be thinking, yes, paying Lively's attorney's fees is part and parcel of this order. But like I say, if any of the US attorneys say differently, then again, I always defer to them. I'm very much aware of my limits. I can interpret the law. But two US attorneys can interpret the same thing entirely different. That is part of litigation. And that is part of, creating arguments for and against. So, the Wayfarer opposition to Stephanie Jones. I haven't read it yet. I caught a footnote and it seemed snarky, so I'm kind of looking forward to this. Bigger. Right, okay. Wayfarer Studios, LLC. Justin Baldoni, Melissa Nathan, and Jennifer Abel, collectively the Wayfarer parties, oppose Stephanie Jones' Works' motion to compel compliance with the untimely discovery subpoena seeking documents from third-party Catherine Case. The subpoena issued on October 17th and calling for documents on October 29th is untimely under the court's Rule 16b Case Management and Scheduling Order, which set the deadline for non-parties to produce documents as August 15th, 2025. And there's a footnote. And this is this footnote I saw that made me sort of chuckle a little. Jones mistakenly asserts that fact discovery deadline was October 10th. While the court extended the deadline to October 10th, it was for the limited purpose of allowing Jones to take 4 depositions and not for all purposes. In any event, the September 30th fact discovery cutoff is not the relevant deadline for third-party productions. The scheduling order provides that the last day for non-parties to produce documents was August 15th, and the last day to move to compel was August 22nd. So Wayfarer basically saying, sorry, Stephanie Jones, you're shit out of luck. Okay. Jones argues that the Wayfarer parties do not have standing to challenge the subpoena. While a party generally lacks standing to challenge a subpoena issued to a third party, absent a claim of privilege or proprietary interest in the subpoenaed matter, the issue of standing is separate and distinct from the timeliness issue, and the fact that the timing of the service of the subpoena violates the scheduling deadlines set by the court forms an independent basis to grant the request to quash. The footnote here. Nathan has a proprietary interest in at least some of the documents which involve her clients. In the non-exclusive list of individuals listed in the subpoena, redacted is Nathan's client, and she has a proprietary interest in those documents given her standing to challenge the subpoena. Because, as further discussed, the subpoena is so broad it may encompass other Nathan clients. That's fair. Accordingly, subpoenas issued after the deadline specified in scheduling order are unenforceable, and courts routinely grant a party's motions to quash third-party subpoenas that are untimely. To the extent the court construes Jones's motion as a request to reopen discovery, it must be denied because Rule 16 scheduling orders may be modified only upon a showing of good cause, which Jones cannot demonstrate. Recognizing she cannot meet her burden, Jones argues a showing of good cause is not required because Case consented to the subpoena. This argument ignores that a scheduling order is not a frivolous piece of paper, idly entered, which can be cavalierly discarded by counsel without peril. The good cause standard is intended not only to ensure fairness to both sides, but also to ensure that district courts can effectively manage their documents and prevent undue delays in the disposition of cases. In any event, Case could not have consented, as the cover letter accompanying the subpoena threatened to name Case as a defendant. Threatened to name Case as a defendant in the lawsuit if she failed to cooperate and comply with the untimely subpoena. Oh, that's so bad. And I love that they've quoted Lyman's own case where he basically, part of his judgment was that use of a subpoena for extortionate purposes smacks of bad faith. I can't wait to see how he tries to get around this. Wow, that's so bad. That's so bad. I said that, I'm sure I said in the video, or like I've said at some point maybe in the comments, like I'm pretty sure that there would have been some kind of deal, like if you give me this, then I won't name you as a defendant. You know, I won't make you one of the does. But you can't say to someone, like, it's one thing to do, you know, like I'm sure that there's been a lot of behind closed doors deals. I have absolutely no doubt. I'm sure Lively did the same thing. Like Stephanie Jones, right? I'll get the subpoena. You'll give me everything, and I won't name you or Jones Works as a defendant in my lawsuit. And that is why I believe Stephanie Jones has never been sued, despite or Stone Jones Works, despite the fact that Jones Works was clearly the PR company that was representing Justin Baldoni and Wayfarer, doing all this bad PR that you know, Blake Lively is complaining of. Like, why would you sue the individual employee, the little person who's got nothing, when you've got the entire employer who is a massive company? Why would you do that? Because you've done a little deal, a little, you know, black market deal behind closed doors, in my opinion. And I can understand that, you know, the reality is that these things happen. Like, you know, these deals are made. But write a cover letter with that accompanies a subpoena to say, if you don't comply with this, I'm going to make you a defendant. Because Stephanie Jones she's got Jen Abel, she's got Wayfarer as defendants. She's also got does 1 through 10. So the door is open for her to start identifying these does. But to do it like that with that kind of wording is extortionate, and that's not okay. And I'm really glad that Wayfarer found a Judge Lyman ruling that effectively says that a use of a subpoena for extortionate purposes smacks of bad faith. In evaluating whether a party has shown good cause for its bid to enforce a late-served subpoena, the primary consideration is whether the moving party can demonstrate diligence. An application to reopen discovery should be denied where the moving party has not persuaded the court that it was impossible to complete the discovery by the established deadline. Jones contends that the untimely subpoena was proper because she did not know until October 17th that the substantially similar subpoena she had served on case on February 17th, as subsequently narrowed, was inadequate to capture all relevant materials. But the documents attached to the Thaler Declaration, which purportedly demonstrate that the original production was inadequate, were produced by July 24, 2025. These documents should immediately have raised a red flag for Jones. At that time, Jones could have taken any number of additional steps, including the fairly minimal and obvious steps of following up with case or seeking relief from the court. Because defendants have not shown why they could not have come to the conclusion that they were missing certain documents and sought the subpoena prior to the close of discovery, it cannot be said that the defendants were sufficiently diligent. Alternatively, Jones could have sought relief from the court. Jones cannot explain why she took no action before the August 15th deadline for production of third-party documents, or why she did not move to compel compliance with the original subpoena by the August 25 deadline. Nor does Jones explain why she did nothing when Case was deposed on September 5th. It was on this date that Jones allegedly learned that Case had written copy for the Stephanie Jones Leaks website and 5 or 6 tweets for an associated disparaging Twitter account, and for 2 websites for other public figures unrelated to this, at Nathan's direction. Jones claims she could not have expected to take any action until she deposed Nathan and Wallace, and they denied involvement with the creation of the website. But this was not new. Nathan had denied any involvement in the creation of the websites when she filed her answer to Jones's complaint on March 21st. If Nathan's response to Casey's testimony was so critical, Jones presumably would not have waited to take Nathan's deposition until the last day of discovery on September 30th. That's a really good point. Why would you wait until the last minute? Sounds, Jones is, like legal terms, the author of her own misfortune here. She has not been diligent. Even after Nathan was deposed, Jones did nothing. The date when third-party Wallace was deposed is not relevant, as his testimony did not add anything to Jones's claims against Nathan. Jones cannot show good cause because she does not explain how the information she learned from the depositions justifies the breadth of the subpoena. Jones claims that she learned information about the Stephanie Jones Leaks websites and other similar smear websites. But the subpoena is not limited to the creation of websites. It also seeks documents concerning social media accounts and posts. Nor is the subpoena limited to websites and social media accounts about Jones. The first request in the subpoena seeks all documents and communications with anyone relating to any websites or social media posts, relating to any negative or derogatory website or social media account, or post about any other individual or entity, listing 9 examples. There is no logical connection between the information allegedly learned on October 10th and the subpoena. In considering whether good cause exists to reopen discovery, another relevant factor a court may consider is whether the discovery is likely to lead to relevant evidence. This factor will weigh against the party moving to reopen discovery when, as here, it is not clear that any information that would be discovered through the additional discovery is truly necessary to the prosecution of the claims. Moreover, although trial is not imminent, Nathan would be prejudiced should discovery on this side issue be reopened because it would increase litigation costs and further delay resolution of this litigation. As Nathan testified, if Case was involved in these websites, it was not on behalf of Nathan or TAG. Permitting compliance with the subpoena will require Nathan to expand resources beyond those already incurred in defending the pending claims. Nathan will have to spend additional time defending against claims which have no connection to the claim involving the Stephanie Jones Leaks website. For the foregoing reasons, the Wayfarer parties respectively request that the court enter an order denying Jones's motion. Yeah, it's well written. Alright, I'm going to see if there's anything else. That's respond. Okay, so the declaration just says that there's something with the Bates number, right? Okay, so there's nothing important there. All right. that one was a good one. I really enjoyed that. So, all right, I will speak to you guys later.